you for the as we begin today's session. With that thought, let us now take a brief moment to, in the spirit of continuous learning and innovation, we begin our day three of our national level FDP program on synergy of sustainability and technological innovation, Viksit Bharat 2047. We are truly privileged to have with us our esteemed resource person, Dr. Santanu, Principal of Bengal College of Engineering and Technology, West Bengal. Dr. Koley is a distinguished academician with over 19 years of teaching and 18 years of research experience. He holds a PhD in philosophy computer science from CSGM University, Kanpur, and is an exceptional innovator with 37 granted patents. His research expertise spans artificial intelligence, machine learning, digital image processing, and cloud computing. Today, he'll be enlightening us on the vital topic IPR and sustainable leadership in the era of technological advancement. Sir, on behalf of the entire Christu Jayanti family, we extend a very warm and heartfelt welcome to you.
Thank you.
I also warmly welcome our respected HOD, Dr. Madhu Dhruva Kumar, our FDP coordinators, the organizing committee, and all our enthusiastic participants who continue to make this program a true success. We now look forward to gaining from your expertise, sir. I now invite Dr. Santanu to address the gathering.
Thank you very much for calling me in the faculty development program titled Synergy and Sustainability and Technological Innovation, Viksit Bharat 2047. And today I'm going to take a lecture on IPR and sustainable leadership in the era of technological advancement. Now, first of all, we need to know what is IPR, and then we'll obviously discuss about sustainable leadership in the era of technological advancement. Now, IPR stands for Intellectual Property Rights. Everybody knows it, but right now, as the theme of our FDP is about Viksit Bharat 2047, so for that, sustainable leadership is required, and the era of technological advancement, it gives us the theme about the neighboring country. We know about China. They are very much Viksit. They are already advanced in their technologies. Now, the government of India has decided to go with the same path where technological advancement, which is the future of India. And for that, we need intellectual property rights, because we know there is no person, there is many person, they are very much talented and they can do many things. But for IPR is a particular thing where we can record our technological advancement. There may be small to big. There are many types of technological advancement, but that is not patented. And that's why we all know about Acharya Jagdish Chandra Bose. On the time of British era, he was the first person when discovered radio. And on that radio technology, we are using mobile phones, the smartphone which we are using, that is using radio technology. We all know radio waves are using, but the full credit goes to Italian scientist Marconi. Why? Because on that time, on the British rule of India, Indians were nowhere. And that's why right now, Government of India has decided to make it IPR as a mandatory thing for the teachers as well as scientists of India, so that any particular invention which can be recorded in Indian patent or IPR department, and then we can, without technological transfer, right now, whenever we get something, everything is technological transfer from different countries. But if we see our back, then we see that there are many technical advancement, and in behind all of them are Indians. But Indians who are working abroad, but Indian government is trying to make them in our country, in our own country. So this is just the beginning. This is the whole about the topic IPR and sustainable leadership in the era of technological advancement. Now we are coming to the exact topic that is we are going to discuss. Now, the main question is, what is intellectual property? Intellectual property that comes from our brain. Our brain, whenever we have something in our brain, obviously that will be good for our society. That intellectual things had been recorded, that those intellectual things need to be recorded. Recorded to where? Recorded to with the Government of India, IPR department, Intellectual Property Rights Department. Now, intellectual property, basically it is divided into two categories. One is industrial property and another is copyright. Within industrial property, we have patents, industrial design, graphical indication, and trademark. Now, we will discuss one by one about all these things. First, intellectual property, as I have already discussed, which comes from your intellect, that is from brain. If you have something in your brain, now that particular thing need to be recorded. Now, the industrial property, it must be industrial. Any particular invention must be make industrial use. Otherwise, if you invent something and there is no industrial use, then it is nowhere. That means that is not in use. So for that, patent is done, industrial design is done, graphical indication is done, as well as trademark is done. So first, patents. If we think about intellectual property rights, first, which comes into our mind, that is patent. Patent means you are recording your invention with any patent agencies. It may be Indian Patent Agency, that is Intellectual Property Department of India, or it may be any other country. Foreign patents, there are UK patent, Australian patent, there are European patent, there are any other, Japan, there are different countries are available to make a particular subject patentable. Next is trademark. We know trademark is a mark for your organization, your brand. Your brand, suppose there is a brand like Adidas. The trademark of that particular organization is something different. There are some logo, there are some trademark, there are some trade secret, etc. And next is copyright. Copyright is actually made on books as well as softwares. There are softwares, whenever you are using Windows operating system, you can see copyright and there is C is written within circle, and then the year of copyright is written 2003 or 2006, 2009, like the year of copyright taken from a particular organization is given there. And next is trade secret. Trade secret is a particular thing where you can suppose you are making a particular, like what can I say? An example is Geo, Reliance Geo. They have their own trade secret to become number one in telecom industry. Now, how they did, it is known to everyone, but no one can follow that without paying them, because the trade secret is again make intellectual property rights. They have registered their rights and nobody could follow the same. If they want, then they have to pay Reliance Industries. Now, our main topic will be in patents, because most of the teachers want to go for patent, and there are several things, there are several parts where patents gives you different criteria for different types and kind of patents. Now, the first question will be, what is patent? Now, patent is the creation of human mind that needs to be protected. The creation of human mind that needs to be protected. A patent owner may give permission to or license other parties to use the invention on mutually agreed terms. So, the owner may also sell the right to the invention to someone else, who will then become the new owner of the patent. So, if Mr. X is inventing something and he is giving the license to some authority, that is Mr. Y, or any organization that is Y, to make the product and make the business out of it, then there are some certain fees to be paid to the owner. Now, a person, they can, he or she can do licensing procedure, or they can completely sell the rights to someone. Then obviously new owner of the patent may do anything with the invention, and on the other side, the inventor will get some money. In terms of money or in terms of other things, it may be discussed between these two parties that we don't know. Now, what kind of inventions can be protected? This is the big question in our mind, that what kind of inventions can be protected. Now, suppose I think I can fly just like a bird. Now I want to make it protected. Is it possible? No. Everything and each and everything cannot be protected, because there are some rules and regulations for that. Because we'll discuss them one after another, that what are the things can be protected and what are not. An invention must, in general, fulfill the following conditions for grant of patent. Now, I'll discuss another thing, that is, what is the meaning of grant of patent. Here, the word grant is very crucial, very important. Whenever we file a particular patent, first, it is published. Published on where? Published onto patent journals. In India, we have Indian Patent Journal. This is not the similar kind of journal we know for the research papers. No, this is not the same kind of journal. Here, only the abstract is published. And actually, Government of India has given the consent. It means Government of India has given you the consent that you have registered the application. They have accepted the application, not grant. Grant means they are granting you for business use or business purpose for a particular product. Now, this is the difference between patent publication and patent grant. So these two are different things, but sometimes publications happens at the beginning for the utility patent, because if we are discussing about patents, then we must discuss another thing, that is patent is generally two types, but nowadays there is another patent comes out. So we'll discuss about three patents actually. First is utility patent. In case of utility patent, it is first published, then it is granted. In case of design patent, that is the second category of patent, it is publication and grant. Both are done at the same time. And both the cases, they are published onto Indian patent journals, as well as you got certificate for that. For both kind of patents, it is either it may be utility patent or it may be design patent. There is another kind of patent available right now that is called seed patent. If you Google it by writing how many kinds of patents are there in India, you will see there are three patents, three types of patents it will show. One is utility patent, second is design patent, and third is seed patent. For seed patent, right now we are not going to discuss, because it is about the seed. That is the seed of different vegetables or different trees or living trees and tree kind of botany kind of things. But in case of utility patent and design patent, they are on different subjects. It may be chemistry, it may be physics, it may be computer science, it may be any engineering branches. So what it needs, that what are the criterias? The first criteria is it must be practical in use. For what? A patent, a particular thing to be patented only when it has some practical use. I said, I want to fly just like a bird. No, that is not possible. That is impossible thing. But it may be possible at some time, because Wright brothers already shown you how to fly. Now aeroplane is being discovered on that time. Now it must be practical. If you want to fly, how? If there must have some procedure. You can fly with just like a bird, but how your wings will be prepared, what materials you will use, how it could be connected with your body. There are different things you have to discuss, and there must have some practical solution. It must not be only bookish knowledge or any particular knowledge. That is, it must be practical, it must be implementable. You have to implement that particular thing. Now, it must show an element of novelty, that is some new characteristic which is not known in the body of existing knowledge in its technical field. The body of existing knowledge is called prior art. Now, novelty must be there. That means new thing. If there is something new in it, then only it can be patented. If somebody already done it before, then it cannot be patented. So this is the first condition was practical use. Second is novelty. And now we are going for the third one. That is, the invention must show an inventive step which could not be deducted by a person with average knowledge of the technical field. Now, the inventive step, what is inventive step? As I have already discussed, that I can fly like birds, but the inventive step must be given, that how the wings will be connected with my arms, how it could be, what material will use, what are the different parameters, other different parameters should be there. That must be practical. So finally, its subject matter must be accepted as patentable under law. That means you are discovering something which is completely unlawful. I am doing, I'm inventing a particular gadget which can took out money from your bank account. No, that cannot be patented because that is not accepted by law. Because without knowing your knowledge, if I am getting money from your account, that is unlawful. So that is not patentable. Now, what is patent? It is a contract with the government. It is the contract with the government. You give the public an invention. They have never seen it before. As I have told you, it is the novelty must be there. So obviously the invention nobody could seen it before. And the government gives you limited monopoly for the patent. Why I'm calling a limited monopoly? That means if we get 100% monopoly to make atom bomb or more destructive than atom bomb, and if I do not have personal relation with any particular country and I put that bomb on that country, it may be today, it is very simple. If you there are biological weapons are there, you do not need to go with atom bombs. There is simple a biological that coronavirus described as a simple virus, which what it can do. And if I do not like a particular country or any particular area or any particular community, and I'm doing that particular thing, no, that is not acceptable. So that's why limited monopoly is given. You cannot do each and everything you want. That is under, if that is under law, then only it can be done, otherwise not. So next question in our mind is who grants patents? Basically, there are national patent offices there for each and every country. National patent office is there, and there are different regions are there. There are regional office that does the work for number of countries such as India, Europe, Africa, Japan, USA, etc. There are all big countries have their own patent office. In India, the patent office is situated in 4 metro cities like Kolkata, Chennai, Mumbai, New Delhi, and where you could like I am from Kolkata, so that's why I have the address of Kolkata. You can obviously find your city which is nearest to you. You could find it out from patent website. Now, here, Sri D.K. Raut, Joint Controller of Patents and Designs, Intellectual Property of his building. This is the address is given. The Kolkata address is given because I have filed many patents over there. That's why I have given that address only. And there are other patent offices are there as well, like European Patent Office, African Regional Industrial Property Organization. Under such regional systems, an application requests protection for the invention in one or more countries, and each country decides as to whether to offer patent protection within its borders. Why? Because within India, if you file patent within India, then within India, you can make your business. You cannot make business in South Africa or European countries. If we want, then obviously you have to file another patent on the same country on the same subject, because patent office is different. Different rules and regulations are there in different countries. There are different countries. There are countries like third world countries, second world and first world countries are there, and there are different rules and regulations. There are different types of people. There are different ways of living for different countries. So the rule is again different for different countries. And one country patent cannot be used in different, but there are an organization that is called WIPO, the World Intellectual Property Organization. This is the global forum for intellectual policies, services, information, and cooperation. Now, what it does, the WIPO administered Patent Cooperation Treaty. This is called PCT, Patent Cooperation Treaty. It's a treaty that means a collaboration between two different parties. This is actually more parties. It provides the filing of single international application, which has the same effect as national applications filed in designated countries. So if you want to make business within in different countries for the same product, then you have to go for WIPO. Like there are some international, like drugs, we can say different international products. They are registered in WIPO. Then only every country, that is multinational companies, they are doing their business in different countries with the same product. So they do not need to go for patent for different countries individually. For that, they have to sign that patent cooperation treaty and they have to apply for WIPO. WIPO is, and here one important thing is that WIPO is not for us. We, the teachers, if we want to file patent, then Indian or UK or any other organization is okay, we could file that. Otherwise, we could, if we make a company, then we could go for WIPO. Through WIPO, an applicant seeking protection may file one application and request protecting in as many as signatory states as needed. That means in WIPO, the countries they have signed in PCT, they can be added, others are not. So if there are, suppose there are, I don't know how many countries are there in the world, maybe 200, but if 110 countries are with this PCT, then only those countries, within the border limits of those countries, a particular organization can business. Other countries are not. Now, patentable subject matters. What are the patentable subject matters? Anything that is man-made. Here we can see different man-made things like a bulb, like a TV, like there is a laptop. So these are patentable subject matters. Now, patentable subject matters are different, maybe different. There are different articles of manufacture, like there is a typewriter, like there are lens of different cameras. So these are patentable subject matters. There may be some process or there may be some methods like water purifying. This is a method. There are different processes are there, different methods are there. In case of when we are purifying water, that is RO is there, UV is there, both are different technology. They have combined the RO and UV. That is again another technology. Before these technology, there was another technology. So there are different technologies available and they are patented according to their needs. Now, there is a picture of satellite. Now, the process or method in which satellites are working, there are different methods, there are different processings are there. So these are patentable subject matters. Now, we'll move towards the designs. Like we can see here, 3 pieces of shoes. Now, there are different designs are available for the same shoe. There are, suppose Adidas is making a shoe and Nike is another company who wants to copy that particular shoe. They cannot, because already it is patented. the design is patented. If it is patented, no other company can copy your product. If they, you can take action. There are certain legal actions will be taken for certain things, certain organization. Now, there is Walt Disney. After death of Walt Disney, Walt Disney, Mr. Walt Disney, cartoon, the Mickey Mouse cartoon has stopped. Why? Because he has patented his Mickey Mouse. You cannot make Mickey Mouse. You may have knowledge of animation. You may have knowledge of cartoon, but you cannot use Mickey Mouse cartoon. Why? Because it is the design of this cartoon is patented already. So it is not transferable. If you want to transfer, then you should check that Walt Disney, what conditions he made to make new Mickey Mouse with that. So if he does not give permissions to anybody, I think not. That's why it is so popular. It was so popular, but right now it is totally vanished from market. So these are the patentable subject matters, and also there are some composition of matter is patentable. Like there are nanomaterials. Actually, last time we are also working on nanomaterials in case of civil engineering to make a particular matter, a particular solution more strengthened and more durable. The composition is changed every time, and the best composition for best weather suited conditions are find out, and then it is patented. If it is patented, nobody could use that one. And then the business methods, there are different business methods are there, as we have already discussed about the business methods of Reliance Industries. There are different business methods for different organizations. You know, the business method of Tata's are different from Ambani's. So obviously their business method cannot, one's business method cannot take by other people. This I may not make you understand because I'm not a MBA people, and MBA people must know what are the different business methods available. But obviously there are business methods available and they are patentable. And if you invent some business method that is successful, then you can go for that. Now, till now, we have discussed about what are patentable. Now we are going to discuss about what are not. What are the things which are not patentable subject matter? Each and everything is not patentable. So there are mathematical formulas and algorithms. They are not patentable. Naturally occurring organisms like rain, wind, like there is summer, winter. These seasons, these are naturally occurring organisms. We cannot make patent. There are laws of natures, like after summer, there would be rainy season. After rainy season, there is winter. After winter, again, it is summer. So this is law of nature. We cannot change and we cannot make it patentable. Next is abstract ideas. If you have any particular idea, as I have already discussed, if I have wings, I could fly just like a bird. But no, it is the abstract idea. You have to discuss each and everything, each and every minute details to the patent authority. Then only they will accept. Otherwise, it is abstract idea. If you have, it is not patentable. Next is natural phenomenon. Obviously, if anything related to nature, it cannot be patentable. So these are the things which are not patentable. Next, we are going to discuss about the patenting procedure. Because till now, what we have discussed, though that is the definition and the other things. Now, the procedure, what procedure we are going to follow, that is important. Uh, because each and every country has different rules and regulation. I will discuss only Indian patent procedure, because if I want to discuss about each and every countries, because there are different rules and regulations for different countries, and I cannot discuss within the certain time period. So patent procedure of India, I'll discuss. So this is the overview of Indian patent procedure. First, what you have to do, you have to prepare your technical document ready. Your technical document is, if it is ready, that means after long years of research, if you have something, then it could be filed through Patent Authority of India. That is called filing of patent application. After patent application, filing of patent application, a particular application number is generated, and you could check online that it is already it is filed, and there are different stages are there for a single patent, and it will show that what you have done. Next, after filing, the publication of the application. As I have already discussed, there are two parts. One is publication of patent, another is grant of patent. So first, publication is done for normal patent. This is the procedure of Indian utility patent. So because there are different rules and regulations for design patent, there are different rules and regulations for seed patent. So what I am discussing here, that is utility patent. Now, publication of the application is there. And the third is examination of the application. After examination, it is called FER. FER stands for First Examination Report. So examination is done, and after examination, the if there is any objections that is being given in the report. Next is response to office actions by the applicant. That means when the patent department examined your application, and then the response should be sent to you, just like research papers. Whenever there is some review, you have to answer the review. So you have to respond the office actions as you are the applicant. Now, there are pre-grant oppositions may be there. Suppose you have filed one patent to Patent Authority of India, and then the opposition is there. I'm there in the opposition that no, this person does not do that thing that is done by me. Maybe some type of inventions done by different people. So hearing is there if it is required, that whoever did it first. Now, the grant or rejection of the patent could be there. Whether if you have did the same thing, then you have to get the grant. Otherwise, if you don't, and maybe there are other reasons also, there are rejections for that. It is not so novel as you are saying it. There are organizations, patent authorities of India is there. If they think it is not patentable, it is not novel, then obviously they may reject. Then post-grant opposition is also there. Suppose your patent is granted, but after that, somebody came and they say, no, this is not your patent, that is my patent. Then again, there is, if any opposition, then again, Patent Authority of India will look into it. Next is renewal of patent. In case of India, the 20 years it is valid. After 20 years, you have to file, you have to renew your patent. But normally what happens, once patent is filed, then it is not renewed, because the technology on the after 20 years, it is changed. It is changed up to certain marks, that new technology occupies the same thing. So after that, abandonment of patent is there, and finally the restoration of patent is there. So these are the 12 steps where the patent procedure is described. Now, patent grant procedure. I'm describing you one procedure. It is totally described for utility patent. And what is the patent grant procedure? First is the filing of patent application, as I have already discussed. Then in case of India, there are two different methods are there. First one is early publication. Early publication means there are some extra fees to be paid to Government of India, that is Patent Authority of India, not directly Government of India. Patent Authority of India is taking some extra fees around 2,500 rupees, and they will publish it within 60 to 120 days. That means maximum 4 months. But normally what we see that within 1 or 2 months it is there. Extra time is already taken by the Patent Authority of India. Next is another procedure is there that is called normal procedure, that is publication after 18 months. You can understand 18 months means 1 year and 6 months. So if you do not pay the extra amount, somebody may say, I cannot pay any extra amount. So publication after 18 months is there. After this publication, what happens? Pre-grant opposition. Pre-grant opposition is there. Suppose somebody wants to excuse me. I'm sorry, there was an important call. That's why it is. So I'm discussing you from the beginning. The patent grant procedure is there, and the filing of application is there. And there are two different procedures, early publication and publication after 18 months. Now, secondly, after publication, there is a pre-grant opposition, and after pre-grant opposition, that is represented by any person. If somebody says it is not your invention, it is their invention, in that case, pre-grant opposition is there. And after that, if it is solved, then it is requested for examination. After examination, the grant, it may be granted, or there may be an refusal. So the publication of grant of patent is happened, and then post grant opposition to grant of patent, that is the constitution of opposition board. If somebody is after grant, if somebody is saying that it is on their work, now the whole decision, whether it will be granted, whether it will be refused, whether if there is any pre-grant opposition, any other person is saying it is their invention, or it is any post-grant opposition, in all cases, the decision is made by the controller of patents, Controller General of Patents. In case of India, it is Unnat P. Pandit. His name is Mr. Unnat P. Pandit. His decision is the final. He will decide whether it is correct or not, whether it is novel or not, whether there is whose invention it is there, whether it will be granted, whether it will be refused, etc. Next is types of patent applications. There are different types of patent applications. One is ordinary application, another is convention application. Obviously, we have already discussed about PCT, that is Patent Cooperation Treaty, that is national phase of application in case of India. And PCT is there for international applications as well, which we have already discussed, that is the WIPO. in case of WIPO, PCT international application is there. Now, the filing of patent applications. There are two types of patent applications. One is provisional, another is complete. That means if you make a provisional application, why provisional application is made and why complete application is made, where it is made, why it is made. There are different questions. Now, a provisional application for patent can be filed at the patent office to claim priority. Priority means suppose my work is going on and I can see there are some other person, he is also doing the same thing. Now, whose patent will be granted? If you do it prior basis, if you inform patent office prior basis that if you are doing that particular thing and that person does not, then you will be the first one. But you may say that if somebody is doing the thing and at the same time it is different, and a complete specification, I'm sorry. Okay. So a provisional application for patent can be filed at the patent office to claim priority. If two different people are doing the same thing, then one is given priority. And how it will be given priority? If he or she informs patent office earlier. So for that, provisional application is made. But there are certain rules and regulations for that. And complete specification has to be filed within 12 months from the date of filing to the provisional application. And the filing fee for provisional or complete application is rupees 1,000, and for individual it is 4,000. Means 1,000 for individuals and 4,000 for non-individuals. That means if you do with some company. Now, about fees, as we are discussing about the fees, there are different fees for different types are there. The application fee for patent sheets claimed, that is rupees 1,000, and fees other than natural person, it is rupees 4,000. For examination request, it is rupees 2,500, and for other person, it is 10,000. For early publication, for a natural person, it is 2,500, and fees for other, that is attorneys and other, that is again 10,000. So that means around 24,000 to be spent if you file a patent through attorney. Now we'll discuss about the publication of the application. A patent application is published in the Patent Office Journal just after 18 months from the priority date, which is the date of filing of the application, which we have already discussed. Now, the filing procedure. The filing of patent application on Form 1. Form 1 is there. Actually, there are different forms. Form 1, Form 9, Form 2, Form 6. There are different forms are there for everything. So Form 1 to be filed for patent filing patent application with pro specification, and that filing could be completed within 12 months after provisional. And if it is published, it may be published, it may not be published. If it is published within 18 months, then the complete specification must be there. And if it is early publication is there, then we can request for examination, that is on Form 18 within 36 months of the filing applications. 36 months means you can understand 3 years. Within filing of 3 years, you have you can request for examination, and then the application could be generated. It may be abandoned or it may be granted. So for that, first examination report FER is generated, FER is issued, and the examination is done. That means after examination done, FER is issued. FER stands for first examination report. And for that, different fees are there. We have already discussed. Now, there are some sample patents, that is portable solar cooker with fold-out reflectors. What we did in our, this patent was done uh, lastly, that is a portable solar cooker with fold-out reflectors. Next is bio-inspired neuromorphic chip for edge AI. This chip was designed by our team, and it is used using AI. And smart internship logbook linked to program outcomes. This is again another patent. Now you can see there are three different types and kinds of patents. First one is for electrical engineering department. Second one is biology as well as computer science department. And obviously, if there is a chip, obviously it is for ECE department, electronics and communication. And finally, the logbook for program outcome. This is for all. You know what program outcome is. If your college is, your university is going for NBA, National Board of Accreditation, then you must know about all the faculties will know about the program outcomes. CO, PO, PSOs are there. So this is the end of the presentation, and this is my phone number. If you want to know more about patents, if you want to file patents and everything, you can contact me. Again, this is my email ID. Again, if you need some knowledge, you can contact. And thank you very much for calling me. If you have any questions in your mind, please ask. I'll be happy to answer if I can. So if you have any questions from the participants.
Participant, if you have any questions, you can ask now. You can put it in chat box. No questions, sir.
Okay.
So you have done it beautifully, sir. All the areas you have covered about the patent. So we required more discussions. Then we will call you once again about the patent. Only
you.
for the patent design or utility patent, sir. Rashmita ma'am.
Thank you very much, sir, for that enlightening and thought-provoking session.
Thank you.
As we conclude day 3, it's my privilege to extend a heartfelt gratitude to Dr. Santanu for his inspiring session on IPR and sustainable leadership. Sir, your words have shown us how innovation, when guided by purpose and ethics, can truly shape the vision of Viksit Bharat 2047. A sincere thank you to our HOD, Dr. Madhu Dhruva Kumar, for our constant encouragement, to the FDP coordinators and the organizing committee for their dedicated efforts, and to all our participants for your active engagement and enthusiasm. With that, we conclude our day 3 on a high and inspiring note. We look forward to seeing you all again tomorrow for the day 4 of our activity. Thank you and have a wonderful evening.
Thank you. Same to you.
Yes, sir. Thank you so much that we came to end of the program. So now we will stop the meeting. Thank you, participant. Tomorrow, same timing at 3 o'clock. Please do join on time.